you're doubtless aware, we have conferenced the case before oral argument this morning. We're very familiar with the record and the facts, so you can assume that as you begin your presentations. As you may not be aware, you're being videotaped today. This is a new practice, and these videotapes will be posted for public viewing. So if you would please announce your own name and that of the client you represent when you approach the podium, it would be helpful for that purpose. Each side has 20 minutes for today's argument. And for the appellant, that 20 minutes includes your rebuttal, so you may reserve as much of it as you wish by ending your initial presentation when the desired amount of time is remaining on the clock. And with that, we can begin.
May it please the court. Good morning. My name is Veronica Manolio. I'm from Kellhofer, Manolio, and Firestone, and I represent the appellants in this case, who are the Petersons. And I will apologize in advance because, as you probably know from reading the record, I refer to my client as Detective Wright. And because the court is well-versed in the facts, and I know you've read the factual history, I'm going to make it as brief as possible. Boiled down to its simplest form, Detective Wright was an amazing woman, is an amazing woman, a member of the Surprise Police Department, and worked for the city for more than 5.5 years. She is a distinguished member of our United States military as a Marine. Despite that she's an amazing woman, she suffered a ton of ridicule and harassment for being a woman. When she tested in first position to be moved to a sergeant position, she was harassed and ridiculed beyond belief, to the point where she went up her chain of command, talked to her then interim chief of police, explained how horribly she was treated, and tendered a letter of resignation. Doing so, she hoped the city would stand up for her finally and take action, because this was a series of actions that had been happening for years. These facts...
Let me interrupt you, because I'm
Absolutely.
having some difficulty with the unequivocal nature of her resignation memorandum. It doesn't say, because of the harassment and this parade of horribles that you've described, I feel compelled to resign. It's not equivocal. It doesn't disclose a belief or hope that things would change so that she didn't have to resign. How can we interpret that as anything but an unequivocal resignation as of that date, when she was fully apprised of the facts that, in her view, required the termination?
I think there are two things, Your Honor, that we need to be aware of here. Number one is that I think it would be a very difficult thing to create a bright line rule in Arizona where a letter of resignation has to have specific facts in it that say this is intended unequivocally. In this case, she didn't spell out, I have equivocal doubts, or I've talked to Chief Shaw and he says he's going to try to take this up the chain. If we start dictating that letters of resignation have to have demands or certain equivocal parameters within them, I think we're creating a whole new line of law that doesn't exist in Arizona.
But isn't the converse a problem of equal dimension, if not more? An undisclosed fervent hope, an undisclosed intent actually triggers the running of the statute of limitations. That seems extremely problematic.
It would if it weren't. We already have a solution for that, a question of fact for a jury to decide. In this case, we have her affidavit where she says, I hoped this would help solve the problem, and we have a letter from the chief 8 days later that says, we have now decided. I have met with HR, I've met with the city attorney, and we collectively with the police department, SPD, have decided we are not going to take action. In this instance, and I agree with you that you can't unequivocally give an intent to resign and never have any question as to your statute of limitations. But in this case specifically, there was a question of fact presented. And I say that because the chief's memo shows when she put in her letter of resignation, the chief was still discussing with the Human Resources Department, with the SPD, and with the city attorney, how are we going to resolve this issue? We have a promotional process that isn't working because everyone has come unglued because a woman tested first place.
You know, let me build on Judge Downey's question.
Sure.
by statute, a constructive discharge claim has certain elements. ARS 23-1502 now governs constructive discharge. Evidence of objectively difficult or unpleasant working conditions to the extent that a reasonable employee would feel compelled to resign. Okay. On August the 17th, Ms. Peterson, or Ms. Wright, submitted a letter of resignation. Now, I too am having a hard time kind of reconciling all of these various arguments, because at that point, she submitted a letter of resignation, which presumably she had concluded in her own mind that there was an objectively difficult or unpleasant working condition to the extent and so forth. So how then can she then create a issue of fact because she doesn't put in additional detail into her letter? I mean, and essentially you're, forgive me, but I have the sense that you're creating a bootstrapping argument in which the absence of information in her letter is extending the limitation period, but yet she submitted the letter of resignation, so she had to have determined that was, at that point, too hostile. I just can't keep working here.
I think that here's the issue. She submitted the letter because, as the city requires, and this is amply pled in the complaint, the city requires you to go up a chain of command. When she met with the interim chief of police, he basically says, my hands are tied. I have to meet with the city attorney and human resources to make a decision about how to handle this situation.
That's helpful, but that's not in her declaration. Her declaration simply says she alerted her chain of command. This additional information that you're bringing, and it's just not in her declaration.
When she says, Your Honor, I hoped this would make the city take action, I believe, Your Honor, that that is sufficient to create an issue of fact, because notice, the city does not have any response. There is not a responsive statement that says, no one from the city had a conversation with you. What they say is your intent. And what the city is asking this court to do is to create a bright line rule under RICS, or using intent as the rule in Arizona. It's saying when you have an intent, if we start formulating a rule based on people's intent, we are going to be in a very precarious situation, because there is no doubt that the city did not fire her. The city did not terminate her.
Right, but isn't what you're asking us to do is formulate a rule based on intent rather than a bright line rule based on the date of the resignation?
No, I'm asking the court to say that appreciable harm happens when appreciable harm happens, because that's what Arizona has followed, and that's what the Ninth Circuit has followed. When an employee tenders a letter of resignation and the employer is not saying, yeah, you got to go, when the employer is not saying, we accept it, you're out the door, she could have at any point gone back to the chief and said, you know what, I decided I want to stay. There would not have been an appreciable harm on August 25th had she decided she was going to withdraw her resignation. The appreciable harm happened when her employment terminated. I think the better rule and the safer rule is if an employee tenders a letter of resignation, that the termination is the day they leave their employment. And so long as the city hasn't said, yeah, we agree.
It's definitely a minority rule.
I don't disagree with you that it's a minority rule. The problem is Arizona hasn't addressed this squarely, and if we start asking courts to interpret intent instead of juries, we are undoing the entire statute of limitation
but
issue.
You know, everyone seems to ignore the requirements of the notice of claim, or the claim statute, 12-821. It really talks about, in a sense, intent. It says new, and I'm quoting broadly, the cause of action accrues when the person or the party knows or should have known. Mm-hmm. Okay, that really is, in a sense, analogous to intent. So when did she know or should have known of the sufficiently hostile working environment causing her to believe she had no other option but to, or alternative but to, quit?
Let's hit that straight on,
okay.
Because what I think is really, really horrible in this case is the the notice of claim. I filed a notice of claim, submitted a notice of claim to the city on November 30th. Within 3 months, under the claim statute, you have 180 days. Within 3 months, and on the face of the claim, the very first thing it says is accrual of the claim, August 25th, 2010. Never does a city say, whoa, 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 that's not the accrual
But they don't
date.
have to respond to you.
I totally agree with you.
They have no obligation to respond. They're not stopped.
I agree with you that there's not a stopple. What I'm saying is that I think that right there smacks in the face of what Ms. Wright-Peterson believed from day one, that when her knowledge, her intent, her knowledge was when she received that memo. When she got a memo in her box, like every other employee of the SPD, where the chief says, I recognize, I understand, and I agree, you have been ridiculed, you have been harassed, this has been a hostile working environment. He uses the exact terms. And in reaction, we're decommissioning the sergeant process. That's when she knows, I gotta go.
You wouldn't
Whatever
want us-
I said I was gonna do has to come to fruition.
You would
now.
not want us to create a rule that allows lawyers to define the accrual date, though, by what is essentially a demand letter. would
Not
you?
at all saying that. What I am saying is, in this instance, it was a
That
fact
what
question.
you said is probative of her credibility?
Not
Is-
at all.
Is that,
No, what I'm saying is, in this instance, there was a factual record that should have been assessed by a jury. That's what I'm saying. I am not saying that there should be a bright line rule based on intent, because I think that's a slippery slope. I think that if you start dictating what needs to be in the body of a resignation letter, and let's face it, most people who give a resignation letter in normal working conditions don't know to look up statutes and define what's inside of a resignation letter. I mean, we're educated and we're blessed, but most people don't know that. I think if we define a rule that says what has to be included in a letter of resignation is going to be a slippery slope. What I
I'd like to
think-
go back to something
Sure.
you just mentioned. You said that, and I've read the chief's letter multiple times. He confirmed the hostility, the ridicule, and the other harassing conduct. She was already on notice of that. She had to be. She submitted her letter of resignation, or her notice of resignation. So the only thing that you mentioned that was different, that perhaps she hadn't known before August the 25th, was that the chief was going to decommission or to abort the promotion process. So why is that decision to abort the promotion process, why does that affect when she knew or should have known? How does that interact with the statutory requirements of the claim statute?
Here's why. Because had she changed her mind, which she could have up until September 1 when she walked out the door, had she changed her mind, she couldn't have been promoted into the position that she purposefully and tested for and won, if you will. Despite the fact that she got that accolade, she couldn't get promoted because she was a woman. That's why it changed on that date, because she learned for the first time, I have a huge appreciable harm. Not only am I being harassed, but I cannot be promoted because of the harassment. The entire process is now gone. Very respectfully, I do want to reserve a few minutes for my rebuttal, but I want to address one other thing, because I think that there are two issues very briefly I want to address. Number one is,
23-1502?
it wasn't, but I certainly...
Okay, make it three issues then. Go ahead.
Well, I think that the 23-1502 is very minor in this case, because this wasn't pled as a statutory constructive discharge case. This case was pled as a wrongful termination case, and it was pled as a breach of contract case because of the city's policies. The reason, in my opinion, that 23-1502 didn't need to be followed to the T is because it wasn't specifically pled as a 1502 statutory claim. And I think that Arizona has distinguished a wrongful termination claim from a statutory wrongful discharge case.
You're
I think-
saying that you did not plead and Ms. Peterson has not pursued a constructive discharge claim? That's what you're saying?
That is not, I apologize. What I said is that we did not plead a statutory discharge
Well,
claim.
forgive me, but
The-
that statute was designed to preempt the field when it comes to constructive discharge claims. I recognize there was some common law before that, but the statute preempts the field. Is there some other claim of constructive discharge out there?
It is a wrongful termination claim based on the public policy. I think that where we have gone awry, myself and the city, is that they have said you haven't met the elements in your pleading. Well, that's not what was argued below. What was argued below was that we didn't meet the statute of limitations. Then in further argument and appeal, I believe it was you didn't meet the pleading requirements of the constructive discharge statute. What I would like the court to focus on in rendering a decision is the entire purpose of the statute of limitations. And the purpose of the statute of limitations is not to get parties and go, aha, 8 days, you're late. And the entire purpose of the statute is not to hurt claimants like Ms. Peterson or Ms. Wright. One of the things that was raised below and was never addressed by the trial court was excusable neglect. I asked the trial court, if you want to blame me, I have to take my problem. If it's my fault, you cannot let go of this client's claim, the plaintiff's claim, because I did something wrong, because I failed to recognize the right date. Court told me wouldn't address it. I believe that was an error that requires the court to do an analysis. The other issue that I think is huge in this case is the attorney's fee award. I think that, and I won't go into huge analysis at this juncture because I do want to leave myself some time for rebuttal, but I think that the trial court really erred in two ways. Number one, this court has no basis, no understanding for why attorney's fees were awarded. I asked the court multiple occasions, please give us a reasonable basis, because there was a contract claim and a tort claim. They just alleged it was a statutory contract case. We're entitled to all of our fees. Judge didn't even address it. Additionally, I think that the trial court abused its discretion in awarding fees, the least of which would be that my client is suffering a huge financial burden because of it. It was a prima facie case. It was very, very well pled. The court didn't even address it. But most importantly, the huge lack of billing judgment in the court below. We had one motion and an answer filed in this case, zero discovery, zero pleading practice other than this motion. And the trial court awarded the city over $50,000 in attorney's fees, including fees that they conceded were erroneously billed to this case that should have been billed to another case. And the trial court didn't even sift out those fees that they conceded. I'd ask this court to please consider that's an abuse of discretion, not intentional, I'm sure. But this client who has suffered the harms that they have suffered shouldn't be made to have to pay an attorney fee award on top of that. So for all those reasons, I'm asking this court to reverse the trial court, and I'm going to reserve the rest of my time if I may.
Very well. Thank you.
May it please the court. My name is Emily Kreger. I'm with the law firm Littler Mendelsohn, and I represent the city of Surprise in this matter. At issue in this case is the plaintiff's claims of wrongful termination and breach of contract. She has claimed that she was constructively discharged in order to support those claims. So there is one key date in this litigation that matters with respect to accrual, and that is the date that she decided without question that she could no longer work for the city of Surprise because of the allegedly intolerable working conditions that she was being subjected to.
Is that really the date, or is it the date that she learned that the city wouldn't remedy the problem?
Well, first off, there's nothing in her resignation notice that states that she's putting them on notice of intolerable working conditions. I mean,
how often do people resign? I mean, you've seen, I don't know how many of these emails that go around. People are going to spend more time with their family. They really appreciate all the wonderful things that have happened. How often do people resign leaving a bad taste? You can sort of forgive this kind of resignation letter, can't you?
Well, in the constructive discharge context, when they're saying they're leaving because they've been harassed and they can no longer work there because of the working conditions, plaintiffs do often state that. I can't work here any longer because of all of these reasons. They don't state things like, I thank all those who've supported me and helped me along the way. But regardless, we know that her intent in providing that resignation notice was to resign because of intolerable working conditions, because that's based on the claim she brought.
This motion, the judge granted a motion to dismiss. Mm-hmm. The only evidence we have in the record is her declaration. And in her declaration, she said she submitted a notice to the city. The notice on itself is vanilla at best. And she says in her declaration, my hope was that the city would act and take action against the situation. And a few days later, on August the 25th, the chief confirms, at that point, this is the first time we have anything in writing that confirms a hostile or allegedly hostile work environment. And at that point, the chief says, we're going to terminate the promotion process. So why isn't there just enough to get to a finder of fact to determine whether it was at that point, August 25th, she said, okay, this is just intolerable, I'm out the door. Why not that point versus earlier. Isn't there enough for a fact issue?
Well, I would say no, based on the claim that she brought. She brought a constructive discharge claim. So on its face, she has to prove that when she resigned because of intolerable working conditions. If she's going to argue later on to say, well, I resigned at this point to spend time with my family, but then 5 days later, once I got this letter, or 8 days later, once I got this letter from Chief Schott, I decided that in fact my resignation was because of intolerable working conditions, then her claim fails.
Well,
She's
no,
already
I
made
think-
that decision.
I think what she's going to say is this was intolerable for a long time. This was building and building and building. I put in my resignation in hopes that that would finally send the message and they'd do something about it. When I realized that they weren't, not only weren't they going to do anything about me, but nobody had a chance, that's when I knew I was harmed.
Well,
How is that any less viable a theory than one that says, well, we should really be looking before the letter of resignation, because doubtless she decided this a couple days before.
well, because we know the absolute last. I mean, I see your argument. There's some point prior to her resignation that she realized that she was being subjected to intolerable working conditions. We know that.
Right.
Because that's why she resigned, because we take her claims in this matter on their face,
So
that
should
that's
we be
why she did
litigating
it.
that? When did she, was it so bad that she finally put her foot down in the middle of the night and said, I'm writing a resignation letter. I may not send it for a week, but I'm writing it. Should the claim accrue then?
Well, possibly, but we don't have to do that because we know for certain that it had to have happened at the absolute latest on the date that she submitted her resignation letter and resigned. But the other issue is this was a motion for summary judgment. We put evidence on the record, and the plaintiff could have easily put more evidence in her declaration to support this theory that, in fact, this was the reason for her resignation, but she didn't. The only factual way that she addressed whatever was going through her mind at the point when she submitted the resignation letter and the point when she met with Schott was to say, I hoped that by submitting this, it would motivate the city to change. That is all we have. And so she had the opportunity in this case to put those facts on the record, and she didn't because
Well,
they don't exist.
Take it out of the context of hope then,
Okay.
and put it into the context of what she knew when. If we look at the chief's memo, which happens to be the same date mentioned in the notice of claim, if you look at the date accrual of claim August 25th, ordinarily I wouldn't be inclined to give a lot of significance to that, but it does suggest that that is the moment that she knew that nothing was going to change. It's hard for me to imagine any lawyer putting in August 25th because they know that they want to take an extra week next year, and it'll really help them at the Court of Appeals when they're arguing over the statute of limitations. I mean,
Well-
she could have put in any date if that had been the case, but the date she put in is exactly the date on which a particular piece of knowledge became known. Why isn't that significant?
Well, I mean, part of the problem is that the allegations in the complaint were completely inaccurate with respect to the timing of how these things happened. She claimed in the complaint that the Schott letter accrued it because that was the last fact that occurred that made her conclude that she needed to resign. And the complaint says then she subsequently submitted her letter of resignation.
Well,
but that's not, in fact, the facts in the way that they occurred in this litigation.
Well, forgive me, and I said this was a motion to dismiss. It was on summary judgment. But we go beyond the complaint. We look at the evidence presented by the parties on summary judgment, and her declaration and what Judge Swan just noted, that was not controverted. That is the evidence we have in this case.
That she submitted a letter of resignation and then had a hope, in that with that letter, it was her hope that things would
Right.
change.
Right, and then
the
finally-
Schott letter occurred.
Right, and isn't the question, is there a jury question that it was at that point, August the 25th, it became intolerable because she knew at that point nothing is going to change.
Well, because at issue is when claims accrue. So that's when a person knows that they can sue another person. That's the holding in the Gus Rosenfeld case. So if, in fact, her claim is constructive discharge and the resignation that she resigned at that time on August 17th because she knew she couldn't work there any longer, there's no evidence in the record to suggest, I mean, there's some information that was set forth by plaintiff's counsel in the pleadings that said that was actually the final straw that changed it. But there was nothing in her declaration that supported that fact, that actually reconfirmed a decision that she had already made. And the New Jersey Daniels case, I think, is instructive here because it talks about obviously subsequent conduct by an employer cannot bring about a resignation that has already been tendered. And that's what we have here.
But now let's come back to 23-1502. You contend that it applies, right?
No, she didn't. I don't contend that it applies. I was just responding to their argument that they put forth that somehow it's instructive in this case because it has a 15-day period set forth. She did not bring her claim under that section.
So everybody seems to agree we can ignore that statute for purposes of this case?
Yes.
Okay, that's helpful. Thank you.
Okay. So I guess I just wanted to briefly, I don't know, on the excusable neglect argument, just quickly, I wanted to state that that was never pled at the trial court level. She put a footnote requesting that she have the opportunity to plead it. There was no reason for it not to be put in the pleadings. We did address it. There's no evidence to suggest that that should apply in this case. And with respect to the notice of claim issue, as Judge Norris rightly pointed out, it's not the city's obligation to point out errors in their calculations, and they had filed their notice of claim well before the statutory limitation, and the city would have no idea that they would wait until the latest possible day to file this lawsuit. Any further questions?
No. All right. Thank you very much.
I think the city's, sorry, I apologize. I'm jumping ahead of myself here. I think the city hit the nail on the head. This is a question of accrual. And the record in this case is one on summary judgment, which had a question of fact created by the person, the young lady who gets to talk about when she knew or should have known her harm was appreciable. That's my client, Ms. Wright. What the city has told you is that on its face, this claim doesn't prove her intent. That's right, because the complaint doesn't prove anything on its face. On summary judgment, the only record the court has is what my client says. And what she says is on August 17th, when I gave this letter, I hope something would change. On August 25th, I knew definitively it wouldn't.
Well, what do you do with the argument, though, that on August 17th, she clearly knew that she could sue?
She had no intention of suing. And what the city is
whether
suggesting...
she wanted to sue or not isn't the question that determines accrual. It's whether she could have sued. So what do you do with that?
I think this is what you do with it. You don't encourage people to start contemplating what their future remedies are at the juncture where they're trying to get their employers to sit down and have a resolution. Because you said it best, Your Honor. You said, isn't it true that people all the time give vanilla reasons because either they're hoping to move on in peace or they're hoping that their employers are going to actually do something right? Instead of encouraging people to submit nasty emails or letters that say, this is a hostile working environment. The point when she knew she could sue is when someone agreed with her in writing and said, not only is this an ugly and hostile working environment where you've been ridiculed, but now you don't even have the possibility of becoming a sergeant because of the hostility. We're going to just take away the entire process. That's what changes in this case,
Okay,
and that's
but is
why...
it your contention then that she decided she wanted to sue on the 25th, or that she couldn't have sued before the 25th?
I think that's when she knew her harm was appreciable. That's when she knew it was recognized by the city. This is a hostile working environment, and your harm is, even if you stay here, you aren't getting the promotion you earned.
It's clear that she knew that when she resigned, and that was just corroboration of her own belief.
No, what she knew when she resigned was that if she stayed, she was going to have to continue being bashed for being a woman. She didn't know that she wasn't going to get the promotion that she had earned.
Well, that was another reason to resign, but she knew that she needed to resign as of the date of her letter because of the intolerable working conditions. It may have been an additional reason to resign that she wasn't going to be promoted, but she clearly knew when she wrote the letter that the working conditions were so intolerable she couldn't stay. Unless,
of course, as Chief Schott told her, I'm going to work to make substantial changes. And it's the same thing he said on August 25th, which, as Judge Swan, you amply said it, the reason that date was put on the face of the notice of claim was not just a willy-nilly. It was putting the city on notice that we all believed on this side of the table that's when the harm became appreciable. It wasn't, the entire purpose of the notice of claim statute and the statute of limitations is to put them on notice of what we think the harm is. Wasn't a surprise. It wasn't intended to be sneaky. If it's excusable neglect, don't hurt Alicia Peterson or Alicia Wright. But the whole issue came to a head on August 25th, 2010, and it made the complaint timely, and it shouldn't have been dismissed. At best, a trier of fact should have decided it. Excuse me, at worst, a trier of fact should have decided it. Wasn't an issue for summary adjudication based on the record that we had in front of the court. So I would appreciate it, and those are the facts. The last thing I will tell you, the only reason, Your Honor, that the statute is cited, the 1502, is because I wanted to equate that even Arizona statute says when you give someone 15 days, you're hoping that those 15 days become a rectifying period. And that's what Alicia hoped.
All right.
Thank you.
Thank you very much. Thank you to both sides for your arguments. This matter is now under advisement, and we will issue a written decision in due course. We're going to recess now to allow the next case to set up. Stand in recess.
Oh, I have to switch over. Here we go.